A little over a week ago, after the appeal court postponed the judgment in an appeal filed by the Senate President challenging his trial by the Code of Conduct Tribunal, the appellate court has delivered its judgment. In a split decision, the three-man panel dismissed all 5 issues formulated by the Senate President challenging his arraignment. According to the court, the tribunal can be considered as a court of superior jurisdiction, contrary to the claims by the Senate President. It also held that from the report emanating from the Federal High Court, there was no order of interim injunction with regards to the case. As such, the tribunal did not err in law to have continued the trial. On the issue of quorum, the court ruled that the law setting up the tribunal is silent on the minimum number of members that constitute a quorum for the tribunal to decide a case. Therefore, a panel of 2 judges can go ahead with the trial at the tribunal. The court also held that the Deputy Director in the Office of the Attorney General did not err in law when he filed the charges on behalf of the federal government.
We told them from day one that you are misadvising him. So, and that is the position, and we have vindicated today that their position is not right.
In his dissenting judgment, Justice Joseph Ekanem, who is a member of the panel, did not agree that the Code of Conduct Tribunal is a court of records because it is not included as a court of superior records in the Constitution. However, it has powers to punish anyone who has contravened the Code of Conduct Act where it is appropriate. While Justice Ekanem agreed that in the absence of the Attorney General of the Federation, the Solicitor General can authorize the prosecution of any individual. In the instant case, the law has not been demonstrated. According to him, a mere declaration by the Deputy Director in the Office of the Attorney General that he had been directed by the Solicitor General to file the charges against the Senate President cannot be admissible in law. In view of this, he ruled that the 13-count charge before the tribunal is incompetent and is set aside while discharging the Senate President.
By the decision of the court itself, you can see there was a descending judgment to the by one of the justices. We intend to test the veracity of this judgment. We want to ventilate and exhaust our right of appeal. We'll be testing it in the Supreme Court, inshallah, and so shall we be there.
The battle now shifts to the Supreme Court, where the Senate President, through his lawyers, will be testing the judgment. Amaka Okafo, Channels Television News.